Lord, it was not my expectation that I will stand here today, having stood in this very court about 5 years ago before your brother Justice Luka Kimaru on a matter similar to this. Having appeared before this court again 7 years before, for your very same brother Justice Luka Kimaru on a similar matter. I'm talking about the matter of Miguna and the matter of Willie Kimani. My Lord, the conduct of the first respondent must be deprecated by the court. And in the strongest terms possible. My Lord, the very criminal justice system that the first respondent stands for is incapable of performance but for reliance upon court orders. It will therefore be turning logic over its head to allow the National Police Service, which comes to this court day after day for summons, to compel attendance, for warrants to enable a search, to fail and attend court, to give an explanation as to the whereabouts of 3 Kenyans. Lord, and it's for that reason that at the tail end of this discourse, we will ask the court to do 2 fundamental things. 1, to convict the holder of the office of Inspector General of National Police for contempt of court. And 2, to sentence the holder of that office to the highest permissible penal consequence. And if 6 months is the highest permissible penal consequence, it must be cumulative for the 5 orders hitherto disobeyed. And fundamentally, my Lord, this is not a personal office. It is a public office. So that as you convict and sentence, my Lord, ought to make a declaration of violation of the Constitution. My Lord, allow me just to refer to 3 authorities and in very brief. My Lord, the first case is the case of Dr. Fred Matiang'i, Dr. Fred Matiang'i versus Miguna. Sorry, it's Miguna versus Dr. Fred Matiang'i. It's petition number 51 of 2018. It's reported as 2018 EKLR. Lord, your brother, Justice Odunga, as he then was a judge of the High Court, was met with a case where the then Cabinet Secretary for Interior had refused, 1, to appear in court and explain the whereabouts of Dr. Miguna. And secondly, had failed to produce Miguna in court. Lord, at paragraph 11 of the decision made by the judge, your brother judge, he underscored a fundamental concept. He said, in this case, it is clear that the respondents are the ones in charge of security in this country. They are in effect in charge of execution of warrants of arrest. They have clearly shown that they have no respect for the rule of law and will not comply with the orders of this court. Lord, in reliance upon that lamentation, Justice Odunga proceeded to declare the contemnors there as having violated Article 10 of the Constitution. Rightfully so, because we asked for that declaration in order that Fred Matiang'i, the then Director of Criminal Investigation, George Kinoti, and all the respondents should not hold public office. We want Gilbert Masengeli not to hold public office, because this is not his personal property. My Lord, the second authority I want to refer your Lordship to is miscellaneous criminal application number 57 of 2018. It's reported as 2018 EKLR.
My Lord, Mr. Wenga, we did serve them on Friday, my Lord. On Friday, my Lord, via email, they were served on both their emails, my Lord. The same authorities and the list of process, my Lord. My Lord, they can open their emails right away. They can find it.
My Lord, this is a serious enterprise. My classmate Charles is a studious practitioner of law. He asked this authorities. And we argued these cases with him. They have been served upon him.
I don't have nothing to authorities.
That's okay. Thank you so much. Well, the second decision that I'm referring to, that is the case miscellaneous criminal application number 57 of 2018, reported as 2018 EKLR. The responsibility, similar to the one bestowed upon you, fell on the shoulder of your brother, Justice Luka Kimaru, a judge of the High Court as he then was. And my Lord, significant to this enterprise is what the judge said about the right to be heard. And this is what he said. If the second and third respondents chose not to appear before court and give their extenuating circumstances, the court will have fulfilled its legal obligation of giving the second and third respondents a chance and a hearing before the final verdict. My Lord, simply put, for the ease of understanding of policemen, because these concepts may appear too complex for them. The right to be heard is given. If it is not taken and exercised, the court has exhausted its duty.
There's already a representative.
No, my Lord, this drama should not be countenanced by the court. Mr. Dunstan Omari has made a habit, whenever policemen kill innocent Kenyans, he comes to court to interrupt a serious discourse. So listen to him, but he's represented by capable individuals from the state law office. Just at that point where it said the right to be heard, if given, must be exercised. And if it's not exercised, the court has performed its duty. And then your brother judge concluded thus: as top police officers, the second and third respondents are required to be at the forefront in respecting summons issued to them to appear before the court. The entire criminal justice system will collapse if bonded witnesses fail to appear before the court to give evidence just because they are of the view that they can choose to or not to present themselves before the court. Hook, line, and sinker to Gilbert Masengeli. Lord, my successor twice, Madam President Faith Obiapo, has illustrated the triviality of the events Masengeli was attending to. Let me illuminate them further. He was even attending a concert. In Kenya, a show, a concert, is treated as a matter of national importance. We are ashamed. I'm indeed ashamed to be a Kenyan. 3 Kenyans cannot be accounted for. You are attending a concert and you're telling us that that is a matter of national importance? Lord, let me conclude with a decision by the Court of Appeal in civil application number 1 of 2017, reported as ELR 2018. Civil application number 1 of 2017, 2018 EKLR. Meguna versus, Dr. Fred Matiang'i versus Meguna and others. So this was an appeal from the decision of Luka Kimaru. But when we appeared before the Court of Appeal, we cited the case of Jones versus Bill Clinton. And the Court of Appeal adopted our submissions word for word. And my Lord, in the case of Bill Clinton, if I may paraphrase, this is what Chief Judge Susan Welber had held. In that regard, there simply is no escaping the fact that the President deliberately violated this court's discovery orders and thereby undermined the integrity of the judicial system. Sanctions must be imposed, not only to redress the President's misconduct, but to deter others who might themselves consider emulating the President of the United States by engaging in misconduct that undermines the integrity of the judicial system. Yes, I'll give this one. And my Lord, say for the Gen Zs who are not there when these matters were happening in the United States of America, we all know that this is the decision that disgraced President Bill Clinton. He never recovered. My Lord, I've handed over the authority to the court. My Lord, Gilbert Masengeli must never recover. Let him be a destitute, a disgrace, a misfit of the law, as he has chosen that to be his ultimate path. My Lord, the Court of Appeal concluded its analysis of that matter with the following strong words. When courts issue orders, they do not do so as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and quite regardless of his status or standing in society, to decide whether or not to obey, to choose which to obey and which to ignore, or negotiate the manner of his compliance. Lord, what my learned colleague has exposed us to is exactly what the Court of Appeal has said should not be done. To negotiate the manner of compliance. Lord, in conclusion, I beseech the court to come to the finding that the first respondent, and in particular, Gilbert Masengeli, has been given the right to be heard. He has refused to exercise the right to be heard. Gilbert Masengeli, as an individual holding public office, must of necessity bear personal responsibility. So that, my Lord, as we ask you to impose the heaviest penal consequence of 6 months times 5, Lord, we also ask you, in the event that you will be minded to give a penalty of a fine, the fine be borne personally by Mr. Gilbert Masengeli, to be deducted from his salary, as was the case for Mr. Kinoti when Justice Odunga dealt with him. And my Lord, we will also ask that we have a return date when the registrar of this court will come and confirm compliance of both penalties. On the penal one, that he has surrendered himself to committee maximum prison, and on the fine, that it has been deducted from his salary. Lord, as I sit down, I'm still saddened. Played a big role in putting this government into office. I'm ashamed, profoundly ashamed, because this is the only cabinet in the history of Kenya that has a majority of lawyers. The cabinet secretary in charge of Interior is a lawyer, a professor of law. Thank you, my Lord. That underscores my disappointment. I beseech you to convict Gilbert Masengeli.
My Lord,